Solicitor, we will need to finish at the latest by 4:10 this afternoon. If there's a convenient moment shortly before that, all well and good, but anyway, that's the deadline.
All I suspect will depend. I'm nearly finished on ground two. Ground
yes.
3 will not occupy the court for an inordinate amount of time, even on my best case. And then it depends upon what my lords and my lady wish me to do with ground 1.
All right, well, we'll see what we
So, but I'll bear in mind the importance of keeping an eye to the clock.
Very good. Thank you.
May I just go back on 3 points from this morning, 2 where questions were raised of me or points made to me, and the third, which is just administrative. Deal with the third one first, the administrative point. We are going to provide the court overnight with a very short, pithy document limited to just the 3 judgments, which does the heavy lifting on severability, assuming one gets over the principle.
Yes.
And gets into the detail. And we will try and get that to learned friends and agreed, if at all possible, as being accurate. It won't contain submission, it'll just be analysis.
Right. Well, agreed if you can, but I think don't take too much time trying to agree it, because obviously it's important that everybody has it. And if it's not agreed, then Mr. Fulton can explain why not.
Of course, I quite understand, and thank you for the encouragement. We'll do that. Secondly, my Lord Justice Mayles asked me about what did Professor Brewer-Carias reply. This was apropos paragraph 207 of the judgment. The way the point was put, according to paragraph 207 of Mrs. Justice Cockrell's judgment, which is page 211,
yes,
is this. All the rulings derive from the conclusion of the Constitutional Chamber, preceded by the Electoral Chamber, that the actions of the National Assembly are null, as you put it, and their view as regards Mr. Guaidó, 2 separate causes. And you then asked, what did he reply? Can I show you, please, the reply? It's in Supplementary Bundle 1, tab 8. And it's bundle page 144 in the bottom right-hand corner. And within the mini script, it's internal page 75, so top right-hand section. So the full passage reads as follows, picking it up at line 15. All the rulings derive from the conclusion of the Constitutional Chamber, preceded by the Electoral Chamber, that the actions of the National Assembly are null, as you put it, and their view as regards Mr. Guaidó, 2 separate causes, correct? Yes? Answer, yes. And then we go on from there. I wasn't going to trouble you to look at the rest of it. It just becomes hard to follow. So to put the point shortly, my lords, my lady, Professor Brewer-Carias agreed with the proposition I put to him, which say is supportive of our arguments on factual severability.
I might like to turn to pages 77 and 78 of the transcript.
From line 3?
From line 77, 13 and onwards.
Thank you.
Mm-hmm.
Thank you. As I said, this becomes very conversational in the usual way. I'm suggested to invite you to look at page 82. lines 4 through to 15 is suggested from those behind me. I'm sure it's a good suggestion.
Yes.
So we submit that the witness's response, unglossed, is helpful to us, not dispositive of the issue, but helpful, and is the passage which I hope is helpful in answering my Lord's question.
Thank you very much.
Turn to the second question, which is, forgive me, not so much a question as an observation from my Lady Justice Falk. On the conclusion on holistic approach and the extent to which I was submitting to your ladyship that it washed across the reasoning that is then reflected in paragraph 205. Can I invite you please to go in the judgment of Mrs. Justice Cockrell to paragraph 203 on page 210. I know we've been here before, but just to make this point. As the learned judge says at the start of paragraph 203, in a sense that, i.e. the prior analysis, decides the question. It was not suggested by the Maduro Board that if I concurred with the starting point analysis, there was still any scope for the judgment not being out of step with the one voice doctrine. And then in paragraph 204, learned judge makes clear that her conclusion on the facts was driven, or at the very least coloured, we would submit, by her conclusion on the law, of which we make no criticism, we just disagree. And then 203, again, the Maduro Board submissions rather focused on the question of whether, if its test was right, the reasoning was severable. And then this on 204 then closes the point off. The opening words of 204, however, there is to some extent a crossover between the 2 points, because it might be said that absence of the severability tends to correlate with the position of Mr. Guaidó being the starting point. So, to borrow, if I may, from the learned judge's own language, the reasoning is interwoven, and it is all part of the warp and weft of her judgment, that the one informs the other. That said, those are the only points I wanted to come back on from this morning's hearing. Can I just conclude our submissions on ground 2 and then turn to deal with ground 3? As regards the conclusion, our disagreement with the trial judgment on this ground comes to this. We submit that the learned judge erred in her interpretation of the Supreme Court's decision on recognition, which led her to reject the possibility of severability, which made it inevitable she would reject our evidence as to the parts of the judgments which could be severed and recognised, even if the one voice principle precluded the courts of England and Wales recognising the other parts. And stepping back, on this ground, I would respectfully reiterate our primary position that our original basis for the second ground of appeal, which is right in itself, has in fact been overtaken, for reasons I explained earlier, by a new and different argument based on the new facts as they are. The one voice policy we submit applies to the recognition of foreign judgments only if there is an executive certificate in place. The relevant time for the one voice policy to be applied is when the recognition is sought, rather than when the foreign judgment was given, which may be arbitrary and irrelevant from the perspective of English public policy, which is a movable feast and has to be dealt with here and now and today. In those circumstances, and since there is now no executive certificate in place as regards Venezuela, the one voice policy can have no application, and the second ground of appeal, in our respective submission, falls in our favour. May I please now...
Isn't the contrast not between, on the one hand, the time when the English court is considering whether to recognise the judgment and the time when the judgment is given, but rather between the time when the English court is deciding whether to recognise the judgment and the time when the act, which is said to be an act of state, is committed. To the extent there's any difference between those, it may not make a difference in this case, but in principle, what we're concerned with is whether the act of Mr. Guaidó in appointing the board is an act of state into which the English court can't inquire.
Yes.
And therefore, it is that question which one voice potentially determines.
Yes, I mean, I find it very hard to quarrel with your lordship's analysis, and I'm not
Well, feel free.
Well, thank you. As you would know, it wouldn't stop me. But I understand exactly what my lord says, but I wonder whether the analysis is actually a slightly different one, and it is simpler. And it is this, and I think I've given this submission previously, so I do hate to repeat myself, but I'll just rephrase this. The difference is one of the application of public policy. At what point does a court, faced with the issue of application of the one voice principle?
No, I follow entirely. It's your point is that that question should be addressed at the time when the court is considering whether to give effect to the act in question, i.e. now. I was just wondering whether the other candidate, the Guaidó Board's candidate, would be the date of the Venezuelan judgment or the date of the appointment of the Guaidó Board.
Yes, I mean, the short answer, I think, would be that those issues don't necessarily in and of themselves engage with UK public policy at all. And the point of intersection is, the critical moment, therefore, is when the English court, with or without executive assistance, comes to consider the effect or recognition to be given to an act of state or the judgment thereupon. And so I was giving this matter further thought over the short adjournment, as you might hope. And with the greatest possible respect, we do stand by our submission at the appropriate time is now, because how else can the court say to itself it has considered the public policy other than as at today? And that public policy has to be informed by the executive's position, and the executive's position is transformed from where it was before. The answer to my own question is, because this is an appeal against the decision of Mrs. Justice Cockrell reached in the autumn of 2022, and that's what we're looking at, and we're having to ask ourselves whether the learned judge was right or wrong. But actually, are you? Or are you asking yourselves whether that part of the judgment, through no criticism whatsoever of her ladyship, none of it, who came to a decision which we criticised for other reasons with respect to her, came to a decision on the materials before her there and then as remitted, the position has now totally changed. And I suppose this raises the anterior question of how is an appellate court to resolve a situation that has played out here, perhaps uniquely, where there has been a fundamental shift in the underlying factual matrix that gave life to the arguments that held sway in the Supreme Court. Not before my lords, but in the Supreme Court, and then informed the basis upon which the remittal to this commercial court took place, and now leads to this appeal. How is a court of appeal to deal with that when the position changes? But I fear I'm in grave danger of
we have got your point.
Yes, of taking too much on this, and your lordship and ladyship are very patient, so I'll not run that risk any further and carry on with the third ground of appeal.
Yes.
Natural justice. Can I be frank? Preparing for these submissions, one recognises there is a rhythm to merit in an argument, and that sometimes the rise and fall of that path towards success or failure ebbs and flows in its gradient and in its difficulty. And I recognise that natural justice poses for us a sharp rise in the incline of the path we have to tread to win successfully, to win the appeal. So please take as read, as before Mrs. Justice Cockrell, so as before this court, we recognise the problems. You will understand none of this is of my client's making, none of it. But we are where we are, and we have to deal with the situation as it is. Interestingly, we submit that the natural justice argument, despite the very unpromising start that I have just sketched for you, carefully analysed, has merit. It is the point in our argument where the tension, which is ever present in this case, of a court in this jurisdiction sitting in judgment on the apex court of Venezuela, which has, unlike Britain, a written constitution, the court exercising concentrated constitutional review or control of judicial review through its constitutional chamber, comes sharpest, especially when the trial was conducted against the heavy backdrop of the attempt that did not succeed to prove a lack of independence or impartiality. So it means that the argument comes before you, stripped of that background, and for the court to ask and answer a question, which is whether or not the foreign judgments should be impeached if they were obtained opposed to natural justice. It is common ground, my lords, my lady, that the Guaidó Board was not notified of the STJ proceedings. It is common ground they were not invited to make representations. However, we say that is not the end of the story as regards natural justice. Our case is that in paragraph 239 of her ladyship's judgment, the learned judge erred in deciding that the STJ judgment should not be recognised on the grounds they involved either, using her words, a serious, clear breach of natural and substantive justice and a flagrant denial of the right to a fair trial under the ECHR Article 6. Specifically, with your leave, we will make 4 overarching points in our submissions. 1, there was a failure, with the greatest possible respect, to take into account the wider context of the STJ judgments. Our first point is that natural justice is not a monolithic set of principles, and its requirements differ with a nimbleness typical of the common law, depending on the context. The learned judge should have taken this important consideration more into account when considering whether the procedures of the constitutional chamber of the STJ were appropriate in light of the exceptional circumstances, which I shall come in a moment, which the court found itself, a fortiori in the light of the matters submitted in respect to the other points arising on this appeal. Second criticism, in headline form, is an echo of what I said before about the intersection with the in rem point under ground 1. And by that I mean this. Our second submission is that the learned judge failed to acknowledge that natural justice does not require the same notice requirements to affected parties in the case of an in rem judgment as might be required in personam case between individual private parties. This is where we submit an example of where we submit the grounds interlock or one informs the other. Thirdly, there was a failure to take into account local remedies. So our third submission is that the learned judge failed to take into account the availability of local remedies in Venezuela. And fourthly, there was a failure properly to apply the flagrant standard under the ECHR. Our fourth submission is, in view of the above, there was no breach of natural justice and no breach of Article 6. I will now develop our submissions shortly as to each, and then I've done. So, failure to take into account the wider context of the STJ judgments. The alleged breaches of natural justice are detailed in paragraph 219 of the judgment, which is on the core bundle, page 213. And at the highest level, relate to an alleged failure to treat the Guaidó Board fairly. And in particular, it is the requirement that parties be notified and heard that is in play in this instance. As I say, for the learned judge at trial, the context was the overbearing amount of materials that had been provided to her on bias and lack of impartiality. And at least my lady and my lords are spared all that today. The key point of principle we would emphasise is that the duty of fairness varies widely according to context, the court in question, and the jurisdiction. And our position is that the context of the Constitutional Court judgments in the civil law state regime in play in Venezuela is vastly different from the paradigm of civil proceedings in English courts between two private parties and relating to in personam claims. The Constitutional Court proceedings may not have adopted those standards, but they are not the standards which apply in this case. Instead, to take as the starting point that foreign court proceedings should be like proceedings in this country and proceed in the same way as regards natural justice and procedural fairness would be a misstep. Of course, public policy itself a concept which flexes given the context under scrutiny. Perhaps, to paraphrase slightly how the judge put it, was the procedure followed such as might be labelled manifestly insufficient as judged by any civilised standard. Must not be offended, but that does not mean that the procedure abroad needs to replicate English procedure. Always remembering that procedure is the means to achieving justice, not the end in and of itself. And in the instant cases, we are concerned with the Constitutional Chamber of the STJ pronouncing on the constitutionality of certain acts and issuing judgments that are erga omnes. The court has been spared my submissions on erga omnes and in rem, at least thus far. But it is our submission that they are actually one and the same, the purposes of this litigation in any event. It was a submission in which failed before the learned judge, but which we respectfully submit is well-founded in this court. We may or may not have to turn to it, depending upon the court's preferred way forward. We submit that the backdrop to the hearings was an extraordinary constitutional economic crisis. The STJ was not dealing with the Maduro Board and the Guaidó Board in isolation, as it might do under normal circumstances. It was dealing with a situation in which there was an equivalence of exclusion in that no one was there. We were not invited to attend those hearings, just as the Guaidó Board weren't either. But the exclusion ran deeper and wider. The Constitutional Court had ruled, erga omnes, that the transition statute was unconstitutional and therefore invalid, and that was a ruling of long standing. Is it to be suggested, I think not, that the court should have summoned every legislator that made the transition statute, all the appointees of the different entities under it, to be heard? No, of course not. And it is most unlikely the STJ viewed this case in any sort of isolation, as a case of disputed legitimacy of competing boards from the broader constitutional issues on which it had to rule. Its foundation was the long-standing contempt of the National Assembly for 2015. Interestingly, there was a dispute that started whether deputies in question did have representation in the proceedings, the illegality of the transition statute and so forth. I'm not going to repeat it all again, you have the picture, I know. Now, inevitably, we are minutely examining what passed through the lens of Maduro Board versus Guaidó Board. And we submit that this has a tendency to skew the image. We would put it as plainly as this, recognizing the boldness of the propositions I'm about to articulate. Neither Mr. Guaidó nor the Guaidó Board had a right to be notified or heard. The STJ did not overlook or ignore requirements, let alone a legal obligation to the contrary. And the STJ was justified to proceed in the circumstances in which it was, constituted as it was, dealing with issues that it had to, as it did. Now, the extent to which it is helpful to my lords, my lady, to rehearse the trite principles of English law, that the requirements of natural justice vary according to context, I doubt. I don't think it's something which authority is really needed. If it were, and I'll just give you the references, we've got De Smith, Authorities Bundle, tab 35, page 1216. We've also got, that's a paragraph 7002. Same again, same authority, same bundle, 2 pages on 7040, which emphasises the flexibility of procedural fairness. Lloyd and McMahon, Speech of Lord Bridge, so-called rules of natural justice are not engraved on tablets of stone. This is, I realise, very, very familiar ground. But the important point, I think, is perhaps this. It is well established that there are certain situations where, even under our regime, entire proceedings can take place without the knowledge of a party, even on in personam actions, consistent with natural justice. And there are numerous of them. None of them are a perfect fit. None of them are a template for what took place in Venezuela, and that is no surprise. But they are illustrative that even in as developed a legal democracy, if I can call it that, as this country, sitting in judgment on others, rightly or wrongly, there are examples where, without notice applications, judicial review of executive actions, closed material procedures, etc., there are examples of where proceedings take place, even in personam proceedings, in the absence of one of the parties. And of course, it is not submitted, as I stress, any of those specific situations apply here. They merely illustrate the general point. And to the extent that there is an irreducible core of natural justice in terms of audi alteram partem, it is that the arguments which might conceivably be made by the affected parties are, to the extent possible, considered by the relevant tribunal in its decision-making process. Otherwise, it is a wrong without a hurt. And thus, to hear another side does not always mean literally to hear the other side. It is sometimes to require the one side to put the other's points full and frank in injunction proceedings, for example. Just but one such example. Now, the context vis-à-vis foreign courts is this. The analysis I've just been outlining applies to the procedures of foreign tribunals, which, as the learned judge rightly recognised at paragraph 223 in her judgment, may have different procedural nuances, and its respect of which English courts ought to exercise circumspection. Thus, the points concerning what is fairly required to ensure that argument is heard applies a fortiori in circumstances where the tribunal adopts an inquisitorial as opposed to an adversarial stance. In this regard, the Constitutional Chamber, the STJ, operates on a quite different basis from the English courts, which do not commence litigation of their own accord. And as noted by the learned judge in paragraph 233 of her judgment, the STJ is empowered to initiate proceedings of its own motion with no originating party via articles of the Constitution, and to review ex officio via the concentrated constitutional review method emergency decrees. So one is dealing with a structure of a very different order to anything that we have here. And in considering the recognition of foreign
I follow that, but she goes on to say that this was not her case, rather she accepts the evidence of Professor Brewer-Curias.
Yes.
That was not applicable in
Yes.
this case.
Absolutely, but I was only commenting about the structure. The court structure, forgive me, is very different to anything we have here. Of course you're right, and we don't make any argument to the contrary about the evidence on this point. But it's just when one is applying, the next point I'm about to come to, the rules, how does one do it? So, in considering the recognition of foreign judgments, the question is not whether English standards of procedural fairness have been met, but rather whether, to borrow words from 223 of the judgment again, the mode of citation has been manifestly insufficient as judged by any civilized standard. This provided an echo of the well-known lines from Lord Collins in Ultimo Holdings. For your reference, I don't trouble you to turn to it. Authorities Bundle, tab 15, page 565. Is the court able to find justice will not or may not be done because of endemic corruption in the foreign system? Comity requires that the court be extremely cautious before deciding that there is a risk that justice will not be done in the foreign country by the foreign court, and that is why cogent evidence is required. Comity is also of relevance here, in a context in which the issue is not corruption or lack of independence or impartiality, but rather whether the mode of these judgments of the Constitutional Chamber has been manifestly insufficient by any civilized standard, to keep borrowing the phrase of the learned judge. As a matter of principle, the STJ is a sovereign emanation of the Venezuelan state, and prima facie entitled to respect as such. That is clear from the Supreme Court judgment, which emphasised that there is no judicial hierarchy as between the sovereign emanation of the Venezuelan state and that its judgments were to be assessed in accordance with the ordinary standards of private international law. So how does one apply the contextualizing principles to the facts? The facts on natural justice are not in dispute. But that notwithstanding, the Maduro Board submits that the context of the judgments was very different to the oft pointed to Kafkaesque paradigm of a natural justice breach, where an individual is accused and convicted in secret of an offence of which they had no knowledge. In the unique circumstances of the present case, as we submit the approach the Constitutional Chamber is, there is insufficient to hold there was a manifest insufficiency in process by any civilised standard. First, to repeat the background of the present proceedings, there were two contenders at the time for the head of state of the Republic of Venezuela, Mr. Maduro and Mr. Guaidó. It was a notorious fact, and especially as the parties in this case, that Mr. Guaidó and his colleagues had sought to establish various rival bodies and organs of state in an attempt to wrest control from those appointed by the government of Venezuela, in particular under the transition statute, which purported to provide a legal basis for it. And here one is dealing, of course, one realises, with a group of individuals who, the National Assembly doesn't exist in the sense it's a Zoom creature of Zoom. They met only ever online. The board were scattered across different places in the world, quite a lot in America. Mr. Guaidó, I think, lives in Miami. Some of his directors lived in near Boston, Harvard. And so there is a, to clothe it in a respectable language, as I just have, as to what they were seeking to do as a rival government, must be qualified, my clients would say, a reference to what there actually was, i.e. nothing. And the STJ judgment arose out of the same underlying dispute that I just outlined. The Guaidó Board would have been aware that all legal means possible in Venezuela would be invoked by the government to vindicate its legitimacy. There is a very interesting passage, I shan't make more of it than it deserves, in the evidence of my cross-examination of one of the officers of the Guaidó Board, who knew, as he conceded very well, that this, i.e. legal action before the STJ, was coming, but we regard as a natural reaction from a usurper government. And so there was no surprise about there being court action taken, and the response to it is very interesting, but because there's no engagement with it. Now, I do not go so far as to say they had notice of a particular hearing at a particular date at a particular time. I don't. There's no basis for so suggesting. But I do say that it is instructive to note when one's talking about the applicable standards of necessary in a civilized society, if we're dealing with an in rem judgment, in particular, in constitutional court, in times of crisis, when dealing with a review of the law, to bear in mind how high the bar that must be cleared is set, particularly for non-treaty countries that aren't signed up to conventions such as the European Convention, as Venezuela obviously is not. How high the bar is set, and then against the evidence of what they knew. But it's a make-weight point, but it makes some weight, how much my lords and my lady will decide. In the premises, it is our submission, particularly taking into account due considerations of comity and the other matters that I have pointed to, that the position and procedure adopted by the STJ in this regard did not clear the judge's high bar of manifestly insufficient as judged by any civilized standard. And that is the end. That in the end, that is what matters, not that the English courts might have approached matters in another way. Turn now to the second of our 4 points. Failure to take into account in rem nature of the STJ judgments. As I indicated earlier on when my Lord Justice Mayles invited me to deal with the submissions in this order, I'm perfectly happy to do so, but I'd flagged up then, and I've revisited this, the in rem crossover point, and here it is. But if I proceed on the basis of the submissions as cast, and then my Lord and my Lady will tell me what you want me to do about one, then that may be the best way forward.
Yes, I think so.
Thank you.
Yes.
Thank you. Failure to take into account the in rem nature of the STJ judgments. This ground, obviously this complaint, obviously follows from our prior submission. I shall allow myself the luxury of treating as satisfied for the purpose of this argument, if nothing else, that these are in rem proceedings. Failing to recognise them as such, and failing to acknowledge properly the variable requirements of natural justice applicable in rem cases, resulted in the learned judge, with the grace of respect, regrettably misleading herself. But had the learned judge taken these as in rem judgments, she would have applied the appropriate natural justice standards to the STJ judgments, or judgments with sufficient equivalence as to warrant recognition. The possibility that the intensity of natural justice requirements may be reduced for in rem judgments was noted in paragraph 231 of the judgment. May I just remind you of how it's put there by the learned judge? It's on page 215. The possibility, forgive me, I'll read again. And there might also be some basis for hesitation if the conclusion were that there was something in the nature of the decision, some aspect of its ex hypothesi at this stage in rem nature, which would render the usual rules of natural justice inapplicable. The learned judge went on to say that we couldn't put the matter that high, because it was said the STJ judgment should have been notified to the parties in the present case. As to this, we respectfully submit that the learned judge, for perfectly good reason, having formed the view she did on the non-in rem status of the erga omnes judgments, overlooked the crucial distinction with respect to in personam and in rem judgments, as now set out in the 16th edition of Dicey and the commentary to Rule 51. As the editor's note, for your reference, it's tab 37 in the authorities, page 1231, and it's chapter 14, 117. The only difference in this respect between a judgment in personam and the judgment in rem is that the former is conclusive only between the parties and their representatives, whilst the latter is conclusive against all the world. A foreign judgment in rem is within the scope of Rule 51, even though there may be only one original party thereto. And the importance here is, accordingly, where a judgment in rem can be enforced against the world, it is insufficient for a party resisting enforcement in England to complain they were not a party to the original proceedings. So the posting of the judgment to in personam in rem erga omnes is actually pretty fundamental to the learned judge's approach to this issue under ground 3, as the learned judge herself was good enough to make plain in her judgment as a possibility. The learned judge endorsed a submission at paragraph 231 made by my learned friends that in general in rem judgments, as we understand them, are reached inter partes and argument from those affected. We respectfully submit that is not to the point, and that it elides two things. One, the question of whether a judgment has been reached in rem, with a separate question of whether the judgment meets the requisite natural justice standards to meet recognition and enforcement thresholds. And indeed, the Guaidó Board's written submissions at trial made the opposite point correctly. And if for your reference, it's supplementary bundle tab 38, page 968. I won't trouble you to turn to it now. Paragraph 22.2. Of course, it does not follow that merely because the judgment is in rem, principles of natural justice do not apply. However, in the present case, the Maduro Board submits that the requirements of natural justice, appropriate to the exceptional context of the STJ judgments, were complied with, and the approach of the Constitutional Chamber to the judgments in the exceptional context of these issues, the control of a nation's assets and reserves, and the control of its central bank were manifestly sufficient by any civilized standard. Move now to my penultimate submission under this head, which is the failure to take into account the availability of domestic remedies. It is submitted the judge erred by failing to apply the principle set out within Adams and Cape Industries, that the English court may have regard to the availability of a local remedy. That is pretty trite. The court is also further reminded that a cautious approach is required when considering foreign rules of process. That is, again, trite and comes from Cheshire, not least, tab, Authorities Bundle, tab 32, page 1195. As to this, the learned judge should have held, we submit, that the Guaidó Board could have applied for a review and revocation. And as to this, the analysis of paragraphs 229 to 230 of the judgment as to the rights in Venezuela overlooks the analysis in Mr. Arias's first report and the passages quoted in that from a judgment which he cites, Servio Giulio Leon. And for your reference, although not to turn to it now, it is Supplementary Bundle, tab 14, page 409.
So are you saying she fails to deal with the evidence and reaches a conclusion she was not entitled to?
She is entitled to, but was in error.
But does she deal at all with the argument about applying for review or revocation? I mean,
Yes.
was there? Where does she deal with that?
She deals with it at paragraph 229 to 230. Where she reaches a conclusion you'll see in 230.
Well, sorry.
Well, it may be
I think you've got the wrong. Have you got the right paragraphs there?
Yeah, maybe I haven't understood it, but I thought those were referring to the position before the STJ reaches its decision, rather than what you're now dealing with, which is asking the STJ to change its decision.
Maybe I have a wrong reference. Let me just.
226.
She decides at 227 that there was no route to challenge the judgments. Yes, 226, 227. And then 228.
I mean, what she's dealing with there is the possibility that even though they weren't formally summoned, the Guaidó Board could have said before the decision was made, we want to be heard, and she rules that out. But you're now addressing a different point, which is that after the decision was made, there was a route which the Guaidó Board could have taken, and the questions are, was that an issue below?
Yes.
Does the judge deal with it?
Yes.
following on from that.
I must have, I think probably for the first time, a wrong reference in here, so forgive me. But it was dealt with below.
Right.
She does in 226 refer to either them joining of their own volition or requesting an extension or clarification.
Yes.
Is that what you're referring to?
The evidence in the court below was that there was a constitutional right of any citizen in Venezuela, I paraphrase, a citizen in Venezuela, to challenge any holding, and that was an inalienable right. And it was a point by putting cross-examination to Professor Brewer-Carias, and he agreed that was a fair characterization, but added the important rider that it had to only be exercised in the, I forget his precise words, but learned friend will have them, in the constitutional context in which they arose, or something such as that.
Paragraph 228 is dealing with possible challenges after a decision. Articles 51 and 26 of the Constitution were sought to be relied upon as at trial as the basis of a right to challenge a decision by a non-party, but the judge rejected the relevance, saying the other provisions on which Mr. Arias, that was the Maduro Board's expert, relied, seemed to have no relevance to the point, thereby accepting Professor Brewer-Carias's evidence.
Thank you. Yes, it was Professor Brewer-Carias didn't disagree with the proposition that was put in the I got the transfer reference if you wish it. My recollection is right. They added it's a right that has to be exercised according to the rules of procedure established in each case.
So can you give us that reference?
Yes, of course. So, to rewind, the evidence from Mr. Arias is at Supplementary Bundle, tab 8, page 135, which is the transcript, day 3. Article 26 of the Constitution, which he referred, is at Supplementary Bundle, tab 29, page 800. Article 51 is at Supplementary Bundle, tab 29, page 802. And his explanation that both Articles 26 and 55 refer to the effects of judicial remedy is Supplementary Bundle, tab 8, page 135 again, lines 14 to 16. And the evidence of Professor Brewer-Carias is same tab in the Supplementary Bundle, tab 8, page 137, internal page 47, lines 3 to 25. Those are the references to that short point. And may I move now to the last point on the third ground of appeal, which is no flagrant or any breach of Article 6 of the ECHR in all the premises. It is now common ground that in order for the ECHR to be engaged, that any breach needs to be flagrant. But as to this, it does not appear to be the case that the Guaidó Board is asserting that in the light of the flagrancy requirement, anything is added in practice to the common law requirements. As such, in circumstances where there is no breach of natural justice under common law provisions, there is no breach, let alone a flagrant one, of Article 6. And to a point I made earlier on in passing, you will recall that the authority for the proposition I advanced, namely that a significantly higher bar is to be applied to claims regarding judicial processes in states which are not signatories to the ECHR, with the United States and Montgomery. Authority Bundle, tab 12. But we submit that the Strasbourg jurisprudence, limited as it is in this case, is clear on the proper approach to be taken to judgments of the same nature as the STJ judgments. And we make just two short points and then we close our submissions on natural justice. First, in proceedings involving a large number of individuals, notably those conducted before constitutional courts, following a challenge to legislation, it is not always required or even possible that every concerned person is heard before the court at his Gavella and Croatia Authority Bundle, tab 28, page 1073, internal page 15. And secondly, a right of review has a similar significance in Article 6 cases as in natural justice under common law. The Strasbourg Court has considered that the opportunity to review can cure a fairness-related procedural defect, Kovac and Hungary, where the Strasbourg Court found that it was of no consequence the applicant had not been able to respond to the opponent's appeal brief, as he was given such an opportunity in the context of subsequent review proceedings, which aligns with the point that we were last debating. So from the very difficult and unpromising start, it is our submission that, contrary perhaps to expectation, submissions on natural justice have real merit. But of course, the starting point, or a starting point, to borrow that phrase, is the in rem holding.
Yes. Well, we do want to hear you on in rem. I think, for my part, I found it helpful to deal with it in the order which we have, because if you're wrong on what you've said so far, it doesn't matter. But if you're right on what you've said so far, then we get to the first ground on the basis that the STJ was, first of all, an independent and unbiased tribunal, and secondly, that its procedures in this case were in no breach, did not involve any breach of natural justice or Article 6. And on that basis, as I understand it, you say that it was performing its constitutional functions within the sphere of its responsibilities, to say that certain acts in issue in this case were unlawful under Venezuelan law. And your point really is as straightforward as that, isn't it?
It is.
So, well, on that basis, having, as it were, cleared the ground for grounds 2 and 3, I think you could probably take ground 1 relatively lightly, though we do want to hear you on it.
Yes. Of course. Sorry, forgive me. I'm reminded that I failed to state, and Mr. Dye is right, I did, I think, state it, I apologise, that if and when one considers the record of the proceedings in front of the STJ in those 3 judgments, 5, 6 and 9, it will be noted that the arguments that are recited and taken into account by the court are those that could have been advanced had the absent parties been present to articulate them. I'm grateful to him for reminding me of that fact. Thank you. Ground 1. It is our submission that this ground operates in one of 2 ways. Either the learned judge erred in not holding that the judgments were in rem, and within the reach of the law as presently framed, or 2, if they were not within the framework of the law find that to include them would be right and constitute no more than a modest expansion to the present contours for them to be included. The point is a narrow one, and it may be articulated perhaps in this way. The sole issue is whether the STJ judgments are judgments of a type that are capable of being recognised as judgments with international jurisdiction as a consequence of there being what English law terms in rem judgments. And the Maduro Board submissions are as follows. It is respectfully submitted that the learned judge erred in law in deciding that as a matter of English rule of private law, the STJ judgments should not be recognised by the English courts on the basis they were not in rem. And in summary, the learned judge, with the greatest respect, erred as follows. First, endorsed a false dichotomy between in rem and erga omnes judgments. Secondly, applied a test for the recognition of in rem judgments, which requires them to be labelled or described as such. In other words, a terminological criterion, rather than focusing on the nature and substance of what was decided. Thirdly, had the learned judge applied the correct test, which is purposive rather than terminological, she would have determined that the STJ judgments could be recognised as judgments either first as judgments in rem within existing common law principles, or secondly, as I said, pursuant to a modest and incremental expansion of the common law. As being selective as to what I need say, in light of my Lord Justice Mail's invitation. It is worth just taking a moment to set the scene. First, as confirmed in the judgment, paragraph 151, there is no issue as to whether the STJ judgments are final and conclusive or about their binding effect within Venezuela. That was not an issue. Secondly, and as set out in the Guaidó Board's written submissions, paragraph 7, Core Bundle 2, page 101, and also confirmed in the judgment, there is no dispute as regards subject matter and the raise issue. The STJ judgments are judgments going to status, namely the status of appointments or purported appointments relating to the BCV and the Special Attorney General, the status of laws or resolutions or agreements passed or purportedly passed, and the status of acts done by the National Assembly. That is to say, the STJ judgments made definitive and conclusive pronouncements as to the status of corporate appointments pursuant to purported executive acts. And thirdly, the STJ judgments take effect erga omnes. This position was accepted by the learned judge. See, for example, paragraph 25. The CC of the STJ is able to make erga omnes decisions, as she held, and that reflects the position at trial. There was really no doubt whatsoever about it. The experts prepared a joint memorandum. For your reference, not to turn to it, Supplementary Bundle, tab 15, page 421. The experts agreeing that rulings issued by the Constitutional Chamber in the exercise of concentrated constitutional review have erga omnes or general effects. That was agreed. And fourthly, it is not disputed that insofar as these judgments are as to status, those purported acts took place in Venezuela. And so in sum, our submission is that in circumstances where the raise of the judgment is status, it's in Venezuela, is agreed to be final and binding with erga omnes effects, that these judgments fall to be recognised by the operation of the ordinary principles of private international law applied to those facts and described as in rem judgments. Now we then split our submission into the two parts that I identified. And I'm going to, at the risk of being overly hasty and being stopped by my lord who seeks more detail, I'm going to give the headlines only of our submissions, if I may, on each. Thank you. First error, judgments are, we submit, sufficiently in rem, shorthand. We start with the definition of in rem in Patney, a Privy Council case in which the speech of Lord Mance, quoting from Giant's Dictionary of English Law, is well known to the court, where he sets out that the res, or the thing, which is an in rem judgment applies, can be the kind of subject matter that we're dealing with here. Patney was cited and approved by the Court of Appeal in Saleh versus the Director of the Serious Fraud Office, tab 18, page 706, paragraph 48.
Sorry, do you say that those cases set out the scope of how far the concept of in rem judgments extends in terms of, in our case, status rather than property, as opposed to describing what, broadly, what the effect of an in rem judgment is?
Well, I'm very grateful to my lady for asking me that question, which is central to the issue and obviously, I may say so, very interesting. I think the answer is a little bit of both. I think that what the cases do is to nod towards the fact that A, the list of what may constitute an in rem judgment is not closed. It identifies by way of example what may be, by the use of language, in rem. That literally fasting too hard of any particular word, but that's the flavour of them. And they give the description that my lady posited as the second alternative to what you just put to me. So they do a little bit of each, but above all, they don't close the list. And the list of permissible incremental expansions of those acts that may fall within the reach of in rem is not closed, and nothing in those cases suggests that it might be.
I suppose I want to understand a bit better exactly where you say the line is drawn, or where you need to say it's drawn, given that we're dealing with a central bank here and appointment.
Yes.
In relation to a central bank. Because, there are other examples. For example, private companies incorporated in a state and the validity of appointment of directors and so on. I know there's some case law on liquidators, yes. But I want to understand exactly how far you are going. You may say you don't need to go very far.
Well, I do say you don't need to go very far, because I say, building on what my lady has just said, in the private law sense, where you're dealing with the status of officers of companies, or you're concerned with what falls under the lex incorporationis in any given situation, matters of that sort, it is but a short step from there, if a step at all, to come to the issues of status in a central bank, such as the BCV, that we're concerned with here. But even more importantly, perhaps, is that we submit that we don't have to draw a line, nor is there any line actually drawn. There is no, for example, as my lady knows better than I do, in some areas of law there is a bright line that says you do not go beyond here other than with legislation. And there is an example actually in this sector, in one of the cases we'll come to, where, concerning insolvency, where the court, my lady sees the point before I say it, That doesn't apply here. And so we don't seek to draw a line, nor do we need to, but rather our point is that not that there is some creeping barrage of accretion of in rem invading all sorts of extra space, but that by cautious, incremental, analytical extension, where any of the cautious analytical extension is even needed, you can, the situation in our case fits the right side of the invisible line that isn't drawn.
I suppose part of why I'm asking the question is if you just take the term erga omnes, I mean, in theory, any foreign judgment in relation to anything could just pronounce, we think this should have effect as against the world, but that isn't going to qualify it as for recognition as an in rem judgment, is it?
No.
So it must depend on other factors. I'm trying to understand what your case is.
And I'm grateful for the questions, and I'm trying to answer. Yeah. I think there may be a hunt for a holy grail that cannot be found here, because the search for certainty and finite or definitional terms may be to achieve only a spurious precision, because to overwork this and seek to say, well, if you're right about this, Mr. Desac, then what are the consequences? Because every erga omnes decision could be said to fit into the in rem camp. That can't be right, for reasons that are in my lady's mind already. But if one looks at the facts of what we're dealing with here, the status and of the individuals that we're talking about, and as we develop in our written submissions, take as the starting point other areas where in rem bites, hence the reference to lex incorporationis, hence the reference to some of the other cases that deal with other aspects of usually company procedures and law. We would say that a fortiori it must apply to a central bank and a board which is under a statute and is a constitutional entity, where the declaration against the world of who is the president of the bank, who are the members of the board of the bank, are the sort of matters which are properly of the flavour of in rem. Now, it's a very loose answer to a very precise question, but not because I'm unable to provide one, but I think there is one.
Okay, but one point I particularly caught there was that you're referring to the central bank as being a constitutional entity.
Yes.
This is a constitutional court. Adding a bit you didn't add expressly, but...
No, but it is. And my lady is right to, on the double use of the word constitutional. Yes.
Thank you.
But what is so interesting about this ground, which is, I think, genuinely very, very interesting, is how things shift as one gets into the detail of the argument. So I've mentioned Patney, I've mentioned Salah, and responded to my lady's question. But there is very interesting support for our position, which I don't seek to make too much of, but is pretty fundamental, by the new edition of Dicey that came after the judgment was delivered in this case, and really does change things considerably. Can I just go back a second on this? So, the starting point is paragraph 164 in the judgment. Sorry, I'll just check that reference right. Seems to be there. Yes, 161, page 201. The learned judge there rejected what she quite accurately said was a broad brush approach that I was taking to these submissions. Not an appropriate way forward. A judgment in rem is a very particular thing. Dicey formulates it in this way, and then she sets out the then current edition of Dicey. The position is, Dicey, which is just for your reference, it's in Authorities Bundle 7, page 201. is the source of the learned judge's holding. That first, Dicey is authority for the proposition that the in rem is a very particular thing in and of itself. Secondly, a list of the 4 situations provided by the editors of Dicey.
Sorry, you said tab 7. Have we got the edition that was before the judge?
Yes, that should be Dicey 15. May I just check?
Not tab
That is
7.
the-
I know it's
Tab
30.
37 is, I think,
I
the
think
current,
it-
the current edition.
31 is the 15th edition.
31 is, sorry, wrong reference. 31 is the old edition. And
That was the one the judge
For the
was
judge.
reviewing. Yes.
And 37 is the new edition. Thank you. And it's 1409 in Dicey 15, where the editors said, unless the foreign judgment claims to operate in rem, it cannot be recognised in England as a judgment in rem. So pretty hard-edged. Secondly, in that edition, it gave a list of 4 situations in which foreign judgments have been recognised historically. Possession or property in a thing adjudged to a person, the sale of a thing is decreed in satisfaction of a claim, adjudication of status, such as a decree of nullity or dissolution of marriage, and judgment ordering property to be sold by way of administration in bankruptcy or on death, which were regarded as being closed, which we submitted was not right. But of course it all changes when post the handing down of judgment, the new edition comes out, and that is 37. And if I could take you please to 37, page 1228. See how it is now written, beginning on the 3rd line, 4 lines in from the end of the line. It has been suggested that unless the foreign judgment claims to operate in rem, it cannot be recognised as in England as a judgment in rem. Suggested not least by Dicey in the previous edition. But as a matter of the English rules on the conflict of laws, the real question is not the terminology used by the foreign court, but whether the function of the foreign proceedings is to determine rights and status as against the world. Now, we submit that change, replacing the sentence relied upon by the learned judge with a new language, supports our submission. The editors cite Saleh, which in turn, and as noted, cited Lord Mance in Patney. And the updated content reflects, we would say, an improved and more principled approach, which gets away from the formalistic requirement for the use in foreign judgments of a particular Latin phrase in rem, focusing instead, as I said earlier on, to a purposive construction. What is the fundamental nature of those proceedings and judgment, and specifically, whether that judgment is to be treated as having a sufficiently in rem character, and whether the foreign proceedings were designed to determine the rights or status generally. And when seen in the context of the approach now advocated by Dicey in the 16th edition, it is submitted that the 4 situations to which I alluded before, plainly not exhaustive, are rather examples of situations in which the relevant features of foreign judgments, the function of which determine rights and status as against the world, have been found, and which we respectfully submit doesn't present any sort of bar to the judgments in this case equally qualifying as in rem in English law terms.
Just to be clear,
Yes.
to the extent it's relevant, there is still the list of 4 categories.
There is.
In the new edition.
There is. Yes.
So it slightly begs, possibly just begs the question.
It does.
Going back to my earlier question about, are we talking about what is an in rem judgment in terms of, what falls within that classification as against the scope of where those circumstances in which there can be an in rem judgment?
Yes. Whether it illuminates my lady's question satisfactorily will be for my lady to judge and not me to guess at. But where it leaves us in our respectful submission is this, that the rewriting of DICE 15 to 16 pre-post judgment must, insofar as one is looking now at the learned judge's conclusion in this case on where is the bar for in rem set, call into question, with no, respectfully, no criticism at all, obviously, of the learned judge in this regard, whether she was, in reliance upon a leading textbook, inadvertently misleading herself. Because the change, interestingly, as I say, calling upon the very authorities we cited in argument and the very arguments that we advanced, appears to have crossed the floor, if I can put it in that way, to our side of the argument. And although the 4 examples still exist, if one looks at the text which I just took you to in the detail, where it says it may be thought that the in rem language is to be used, well, none of it is now this. It renders unlikely that those 4 examples are constitute a closed list. They can't. But even if the 4 categories remain and the list is closed, which is not our primary submission, we're still okay, if I can put it in that way, because as you know, the third category is adjudication as to status. We know from paragraph 146, I think it is, from the decision of the Supreme Court, that the appointments here constitute such an act for purposes of this question.
Sorry, which paragraph?
146, I think, from memory. May I just check, so I'm not giving you a...
Of which Supreme Court?
Yes. I think that's right. Yes, for these reasons I consider that Rule 2 applies to an exercise of executive power such as the power of appointment to the board of the BCV. And so when the thing about the third category is it is usually talked about in the cases by reference to that comes in the second clause in the sentence, namely, such as a decree of nullity or dissolution of marriage. But actually status is far wider than that. Therefore,
Well, yes, I don't want to quibble, but is status necessarily the same as exercise of executive power? Because status could be whether a company exists or not, for example.
it certainly could be. But status, we would say, also connotes the appointment of people to hold office.
Yes, you mean the status of the individuals
I do.
who hold the office.
I do.
I mean, here we're not so much concerned with status in its wider aspects as with the lawfulness of the act of a public body or someone purporting to be a public body, purporting to exercise the executive powers of the state.
Yes.
That's what we're concerned with, where one might think that the view of a constitutional court is a particularly relevant consideration.
I agree. was about to move, if I may, to the issue of mistaken distinction between erga omnes and in rem. But in so doing, and noting that that is my next subheading, I wonder whether there is still value in the detail of the submission in light of the exchanges. It is in short, it is our submission that the accurate position of the distinction is that it is a distinction without a difference. That sounds blasé, but what I mean by that is that if one is concerned, as Deutsche 16 entreats one to be focusing upon the essence of the judgment, I paraphrase, but I hope not inaccurate, then the judgments in this case, which the experts agreed and the judge accepted, were erga omnes, bear all of the hallmarks of what otherwise in another jurisdiction would be in rem. And so there was really no distinction practically in this case on the evidence as found by the learned judge between the two conceptually. The wrong turn that was taken below was the fastening on the language rather than upon the purpose, my shorthand. And that's where things went awry.
Yes.
I'm going to leave there the submission on that heading. The next subheading is no requirement that in rem judgments describe themselves as such. Now this is, again, part of the prior point in a sense. We respectfully submit that to hold to the contrary, that there was a requirement for in rem judgments to describe themselves as such, otherwise they don't qualify, is wrong. There was a heavy reliance by the learned judge on a first instance decision in the case called Airfoil. Airfoil, which the judge references in her judgment, was said by the editors of Deutsche 15 to be material, and may have been, as the judge regarded it, the source of some of that was said, but actually it doesn't go as far as 15 does, but it's been overtaken now by events with Deutsche 16, and we respectfully submit, if I can save this for reply in case there is any necessity for me to deal with it. In fact, definitionally, things have moved on, and the law now comes from Saller and Patney and Deutsche 16, and not from Airfoil. So I'm going to, taking advantage of my Lord Justice Now's invitation not to do this at inordinate length, my words, not yours, you're much more polite than that. I'm going to leave that argument there for now. May I then turn lastly, I hope, to our alternative case. So our second alternative, first one is wrong definition, we're not labelling these in rem, but because it does fall within the present contours. But if it doesn't fall within the four corners of in rem judgments at the moment, and there has to be an expansion, then this is our second alternative argument. It's not shorter than the first, but I'll just, if I may, touch upon it. I've done some of this already in answer to, or an attempted answer to my lady's questions, and here what we do is we point to the fact that any expansion here would be merited as incremental and modest, not opening some notional floodgate. Indeed, to the contrary. We draw upon, as you know, in our written submissions, the position in Lex Incorporationis on Lightman and Moss and the relevant law for determining the authority of directors to execute a charge, again alluded to in my answer to my lady's questions. And by reference to who may represent a corporation at its board is a matter of status which by its nature applies towards everyone and should therefore come within the reach of this principle, whether originally or by extension. The Guaidó Board's position is to draw on Rubin and Eurofinance, which is very well known to the court, obviously, from the court's indication. I'm grateful. Which we respectfully submit doesn't really help. It was this case that I had in mind when I indicated earlier on that it's no surprise that when you're dealing potentially with substantial ramifications, changing the requirements as regards in personam recognition in insolvency proceedings, so the court might say this is a matter for Parliament to deal with, not for judge-made law. Not at all surprising that the view of Lord Collins in Rubin was that the legislation was required, but we respectfully submit that is a very long way from here. And we submit that there being no discernible end or break to judicial development through the common law of categories of in rem judgment, that if it is felt necessary by this court, if our primary submission finds favour, obviously, if it is felt necessary to label this argument as an extension, then we respectfully commend it to you as being within the permissible bounds of judge-led, judge-made extension, common law principle. My lords, I think, unless I fail to deal sufficiently with anything or I'm told from behind, more is needed. Those are our submissions on all the grounds of appeal.
Well, thank you very much, Mr. Wilson.
Thank you.
Yes, Mr. Fulton.
My lords, my lady, as we see it, there is a pleasingly neat structure to this appeal. There are 3 grounds. Under each of the 3 grounds, Mr. Lissac must overcome an obstacle as a matter of English legal analysis. And under each of the 3 grounds, he must also overturn first instance findings of fact. And so in relation to ground 2, one voice, the English law point is that the correct test under the one voice principle is that a foreign judgment must take as its starting point that the foreign president or government is the same as that recognised by HMG. And the Venezuelan law point is that there is not here any severable strand of legal reasoning. On ground 3, natural justice, the English law point is that Mr. Lissac must persuade you that a foreign procedural remedy can avoid a finding of a breach of natural justice, even in the case of a failure to notify and a denial of any right to be heard. That's the question left open since Adam and Cape. And then the Venezuelan law point is that Mrs. Justice Cockerell held that there was no such route of redress in fact available under Venezuelan procedure anyway. And then ground 1, in rem, the English law point is that the common law rule about in rem recognition of foreign judgments is confined to judgments about property within the territorial jurisdiction of the foreign court. And the Venezuelan law point is that Venezuelan law has no concept of in rem proceedings and in rem judgments anyway. And so within that framework of 6 distinct points, we suggest there are 2 important themes which run through the English law points and the Venezuelan law points respectively. The theme permeating all of the English law issues is that Mr. Lissac needs to push the law beyond the boundaries of any decided case. On none of the 3 grounds can he point to an even remotely comparable authority which helps him. That's ambitious enough, we would suggest anyway, but made especially difficult by the interplay between grounds 1 and 3, because Mr. Lissac needs to persuade this court not only that the rule for recognition should be acknowledged to be more permissive than either Dicey or any other case has recognised, but also that there is this flexible and fact-sensitive concept of natural justice to permit the recognition of the foreign judgments which he wishes to have recognised here. And he wants to effectively recast the notion that there is some irreducible minimum requirement of a fair trial, and make the whole thing altogether more fact-specific and variable. And because ground 2 is in play also, he needs to say that this court should engage in that sort of overhaul of the common law in order to suit the agenda of those who are aligned with a regime which the UK government continues to describe as illegitimate. And then on all of the Venezuelan law points, Mr. Lissac has an altogether different problem, in that he must overturn multiple and independent findings of fact reached by an experienced commercial court judge after detailed consideration of written and oral evidence. Mrs. Justice Cockrell made careful findings about Venezuelan law after a substantial trial which obviously included the cross-examination of the rival experts. And the principles which govern an appeal in those circumstances are not those to be found in the authorities cited by Mr. Lissac at paragraph 5 of his skeleton. Boas, which is cited, is about a domestic law boundary dispute. Brownlee is about foreign law, but at first instance. The proper approach on appeal has been recently restated by a 7-member board of Privy Council just last week in the case of Perry. That's authorities tab 38, unfortunately not indexed, but hopefully it's found its way to the back of both the hard copies and the electronic versions of the bundle that the court's working from.
Is there a particular reference within Perry?
Yes, there is. I beg your pardon, my lord. I will. It's first of all, if we look at paragraph 2, one sees there that one of the issues was whether foreign findings of foreign law are to be treated any differently. 4 lines down. The appellants argue that findings of fact in relation to foreign law need to be treated differently from other findings of fact. And then the discussion of that issue is then picked up from paragraph 8 under the heading the application to concurrent findings of fact practice, the findings in relation to foreign law. And then at 9, over the page, halfway down the paragraph, in essence, Mr. Brownbill submits the trial judge and the first appellate court can use their legal training and experience to analyse and reach their own conclusions in relation to foreign law. So too may the board, which he submits should not defer to the conclusions of the courts below. The board does not agree. And then at 10, the starting point is that findings in relation to foreign law are findings of fact because a judge is not to be imputed to know foreign law. And then paragraph 11 identifies the task of the trial judge. And then at 12 makes the point that in a common law system, the judge and an appellate court can bring their knowledge and expertise to bear because it's relevant to the question which they need to decide. But what we're really interested in is the 3rd and 4th points appearing at 13 and 14. Thirdly, where the foreign law is in a foreign language, the trial judge will often be dependent on translations of the relevant text, which may or not be precise and which may not be disputed, on the evidence of the foreign law experts to understand the meaning and nuances of the foreign language in the relevant text. And then Lord Hodge here cites with approval the approach of the Court of Appeal as described in Byers and Saudi National Bank, where the court was there having to deal with questions of Islamic law which had been drafted in Arabic. And then 14, fourthly and more widely, where the first instance judge is dependent upon the evidence of foreign law experts who disagree as to the interpretation and application of a foreign law and has to decide issue by issue whose evidence to prefer, precisely our case, the judge will have regard to all of the evidence presented to him. The judge will reach a view based on an assessment of each expert, having regard to each expert's evidence as a whole, and the way in which each expert answered the questions posed in chief and on cross-examination to justify his or her opinions. The judge will thus evaluate the expert's reasoning. Not all of the matters which have influenced the judge in forming a view on which evidence to prefer will always be recorded in any detail in the judgment, or can be ascertained from reading a transcript of the proceedings. The judge will have regard to the whole of the sea of evidence presented to him, whereas an appellate court will only be island hopping. And then citation of the familiar case about trying to overturn findings of orthodox fact, not necessarily foreign law in Farge case. And then Lord Hodge goes out on 15 to say there is thus a spectrum of circumstances in which the principal variable is the degree to which the judge can use his or her skill and experience of domestic law and of the domestic rules of statutory interpretation to ascertain the foreign law and apply it to the case in question. And so on that spectrum, we say we are at the extreme end of unfamiliarity when an English court was being required to consider a civil law system with a written constitution and a general rule that there is no binding precedent, unfamiliar principles including of a court being able to act in certain circumstances ex officio. In fact, it was a constitutional court itself. All of these issues aren't familiar to the English common law system, and the judge was dependent upon the assistance given to her by the two experts. And as to the two experts, Mrs. Justice Cockerell preferred our expert, Professor Brewer-Carias. She introduced this, if we could look first of all at page 129. I'll deal with the details of the evidence below and shall explain why I've preferred the evidence of one witness over another at the point where the issues arise. It is, however, fair to say, and Mr. Lissac QC realistically didn't shy away from this fact, that Professor Brewer-Carias was the expert with by far the greater expertise and authority, a man of enormous distinction and seniority in his field, who was in fact one of the main drafters of the Venezuelan constitution.
Sorry, can you just give...
I beg your pardon. I was reading from page 189, tab 7,
Thank you.
core. And so that's how she set it up, identifying that our expert was by far the more experienced, and such experience as he had was far more relevant to the constitutional issues which she was called to decide upon. And then in relation to every single point on which the two experts differed, she preferred the evidence of Professor Brewer-Carias. In each case, always being careful to identify, even if relatively briefly, her reasons for doing so. I won't go to all of those passages, but the references are 155, 169 and 176, 210, 227 to 230, and 233. And we say that the Maduro Board simply hasn't sought to explain, in respect of any of its three grounds of appeal, why this court should feel it's in a position to overturn the judge's findings and to make new and opposite findings about the content of Venezuelan law, having regard to the principles identified in Perry by Lord Hodge. And although Perry itself is hot off the press and therefore a late inclusion in the bundle, the Court of Appeal position as described in Byers predates the appeal, and we put that in the bundle of authorities at the outset. And we say that Mr. Lissac could and should have engaged in both his skeleton argument and his oral submissions with the appropriate test for inviting the Court of Appeal to overturn findings of foreign law by the first instance judge. And just finally on Perry, we could go back to the authorities bundle, tab 38, page 1260. Paragraph 21, 4 lines down, there's reference to the UK Supreme Court case in Brownlee. That's cited by Mr. Lissac and was referred to. He said that that was the test that he was relying upon as to the approach to foreign law. But one sees from the bottom of that paragraph, 3 lines from the bottom, this appeal is not concerned with how far and in what circumstances a domestic court should now be able to dispense with expert evidence of foreign law. That was the point in Brownlee, Lord Leggatt saying that the concept of there always needing to be expert evidence was now outmoded and the court should take a more flexible approach particularly when so much material is available online in English and can be read by the judge without the assistance of an expert. Lord Hodge is careful to say that Lord Legate's dealing with an entirely different case there, and he goes on, this appeal is concerned with whether and to what extent appellate judges may use their training and experience in domestic law to analyse and review the findings of a fact of a trial judge on foreign law, which is based on the evidence of expert witnesses. In that context, Lord Legate's dicta are consistent with the spectrum approach which the case law in this field supports.
Well, you say we're not really in that area because here the judge did base her findings, at least in part, and you would say in large part, on the evidence of the witness whose evidence she preferred.
My lord, yes, but applying the spectrum approach, we could have been in the area. It could have been the foreign law of the Isle of Man, or perhaps of the United States or a Commonwealth country, where although assisted by expert evidence, it would nevertheless have been relevant that it was a type of law which was more familiar to the first instance court and this court, and where the expertise of the relevant principles could still have been brought to bear, even having regard to the assistance being provided by expert evidence. Where one's at the other end of the spectrum, where it's dealing with entirely unfamiliar principles, and Mr. Justice Foxton had accepted there was plainly a need for expert evidence here, and hence gave limited permission for expert evidence on the question of status of these STJ judgments, as in what they decided or what they purported to decide, and then the requirements of due process under Venezuelan law, that they were always questions which were going to be addressed by expert evidence, and the judge has made her findings, and in the absence of any properly articulated case from Mr. Lissac, that she completely misunderstood the evidence, or that these findings just simply weren't open to her, we say all of her findings under all three of the heads are impregnable in this court, and Mr. Lissac said in terms that was a decision which was open to her, but we say it was wrong. They can't have that in this court. They can try to persuade her of the right answer at first instance, but in this court the opportunity for challenge and certainly reversal is altogether more limited. And one saw it from the island hopping, the exercise of going through the transcript of cross-examination of Professor Brewer-Carrias, where Mr. Lissac sought to persuade the court that he had agreed with our proposition. I hope it was clear from the passages which the court then went to that he did nothing of the sort. But it shows the artificiality.
Well, in fairness, he was answering my question about what was the answer to a particular question.
My lord.
We get the point.
I don't seek to take the court through all of the written evidence and to show how the expert evidence panned out, because the court has to look at all of this through the prism of what the judge decided, and she carefully read all the materials, paid great attention to what was being put and said in cross-examination. The Sergio Tullio judgment, now relied upon in this court, didn't even feature at the trial, didn't even feature in Mr. Arias's report, which was served pursuant to Mr. Justice Foxton's order. It's a point which they've sought to dredge up now on appeal, to try and say that the judge was wrong to have found there was no domestic remedy, because there's a case which they say suggests that there is some route of appeal. It's a completely flawed, with respect, we say misconceived exercise, which is sought to be undertaken here, because these findings of fact in relation to Venezuelan law are fatal to Mr. Lissac under all three of the grounds. So those were just the introductory points as to the structure and themes. Moving then to the substance and first of all, ground 2, one voice, adopting the same order. As I said, the English law point is whether the judge was right to accept our argument about the importance of a foreign judgment proceeding from the correct starting point about the identity of a government or president. The court's seen that the Supreme Court dealt with this at 170 and 177. I don't think I need to go back to those passages. We say that the test being laid down in those paragraphs is simply whether for the English judiciary to recognise a foreign judgment would conflict with the view of the UK executive. That's the expression used by Lord Lloyd-Jones in both paragraphs, would it conflict? And also, that's the same language used in Dicey, would it conflict?
Suppose the foreign court had said there are two independent reasons why the appointment of the Guaidó Board is unlawful. One is that they were made by Mr. Guaidó, who's not the president, because Mr. Maduro is, and the other is something else.
Yes.
If it's actually spelled out that they are independent in that way, is the English court still bound not to recognise that judgment?
We say yes, because the starting point from the court's judgment, obviously leaving aside the severability point, if the court had expressed itself in that way, then the two strands of reasoning would be more readily severable. But on the first part of our case, we do say that it would be an infringement of the one voice principle for the English court to recognise a judgment where the foreign court is starting from the wrong premise as to who the president or government was. There may be a slight nuance if it could be said that there was the two issues had absolutely nothing to do with each other, and that's what the judge contemplates hypothetically, a situation where it might not offend the starting point analysis for there to be some passing reference to the identity of a president or government, where that's completely extraneous. But obviously we're not in that situation, because this is all arising in the context of a constitutional crisis. And so whether or not they are severable in a legal sense, they are factually related. And we say that the starting point analysis emerges from what was said by Lord Justice Popplewell in Mahmood, which is Authorities, tab 21. Tab 21, 765 of the bundle. And then 4 lines down. However, where the alleged unlawfulness doesn't take as its starting point that the government is the government, it inevitably conflicts with the recognition given to the government by HMG and engages the one voice principle. And he goes on to say that the latter is the position in relation to the two particular challenges which are the subject matter of the appeal. This wasn't said in the context of the recognition of judgments, it was just a question of whether the challenges before the English court were permissible, having regard to the one voice principle. But we say that the same logic has to carry over, and was, we say, rightly upheld by Mrs. Justice Cockerell as carrying over to the question of recognition, because there is a conflict with the recognition position if the courts are starting from the wrong starting point. And we say that's a logical, common sense proposition, attaches proper importance to the role of the executive in deciding these questions of recognition, and the importance of the judiciary then speaking with one voice, and to recognise the judgments of a court which continues to declare its allegiance to a president or government which isn't recognised by the UK. One can readily imagine why that causes difficulties, and the judge cited from our skeleton about, as to examples about that, 200 judgment, page 66 in the core, paragraph 200. For example, once HMG had recognised the revolutionary Soviet government of Russia, an English court wouldn't then have recognised the decision of a Tsarist judge who purported to nullify the Soviet confiscations of private property. Similarly, Had there been a judgment in 1949 of the court in Barcelona that the actions of General Franco's government in Bilbao were invalid, then it would have been ignored in this jurisdiction because HMG had by then chosen to recognise the Franco government's sovereign power over the Basque region, by the same token in relation to Iraq. And the reason, in answer to my Lord Justice Mayall's question, underlying the importance of that hardline principle to ensure that the foreign courts are taking the correct starting point, is that it would be impossible for an English court accurately to disentangle or work out whether the secondary reasoning, or the second ratio, had in fact been infected by the court's attitude on the question of identity of the president or government. And one of the themes of Mr. Lissak's criticisms of the judge has been that she, with respect to her, was unable to put to one side the logic of her first argument when dealing in the alternative with a second argument. If one's looking at judgments of a foreign court, which has taken the opposite view to our own government about who is in charge or who ought to be in charge, then it's obviously unsatisfactory then to recognise the decisions of that court, even if logically it can be said that there are two different strands of reasoning. And so
that may partially answer a question, which is what is the real difference between the starting point concept and reasoning, as in could be the starting point of the reasoning, point A of the reasoning. But I think your point is you don't need to demonstrate.
You don't need, exactly. You have to, the starting point, as it was put by Lord Justice Popplewell, the starting point is whether the president is the president or the government is the government. That's the starting point. In which world are you operating? And as we say in our skeleton, questions of one voice only arise in the context of some form of dispute over sovereignty, where you have rival factions and forces, invading armies, civil wars, constitutional crises such as this one. And so there are, by their nature, going to be factions loyal to one side or the other. And we say it would be intolerable as a matter of foreign policy if the English court was required to recognise the decisions of a foreign government who was backing the wrong, foreign court who was, in the eyes of HMG, backing the wrong horse. Because obviously it wouldn't be very hard for a foreign court, knowing that those were the rules of recognition in London, to strike down the acts of the person recognised as the rightful president or government, and say, right, well, I've got two reasons. I don't recognise him as the president, but I'm going to strike his acts down on another basis, and then the English court has to accept that as being valid. And the exception to the Act of State doctrine, as identified for the first time by the Supreme Court in this case, obviously is intended to operate as a rule of law exception to allow, in the example given by Lord Lloyd Jones, the possibility, for instance, of the US Supreme Court striking down as unconstitutional the acts of a US president. But all of that assumes, tacitly, that the US Supreme Court is adopting the same view as the UK government as to who the president even is. And if it's starting from the wrong starting point, if after some not so hypothetical electoral dispute, the US Supreme Court was taking a different view to the UK about the identity of the US president, then it would be intolerable as an interference with UK foreign policy for the US court's judgments to be capable of recognition in London, even though they were completely divergent from the recognition position which had been adopted. So we do say, both as a matter of language, in terms of Lord Lloyd Jones's conception of a conflict with HMG recognition, and in terms of the proposition from Mahmoud of the starting point, but also in terms of the inherent logic of the approach and the fact that one voice exists in order to ensure an alignment between the two branches of the state, then the judge was absolutely right to apply the starting point analysis. And so we win on that basis. But we say, as a matter of fact, and in assuming in the Maduro Board's favour that my starting point argument was wrong, she went on to hold that the reasoning here was not severable. And that's at 204 to 213 of her judgment. And applying the Perry approach, those are careful findings based upon the Venezuelan law evidence. She obviously read the STJ judgments herself in order to form a view about the importance of the analysis and what they purported to decide, but she was obviously greatly assisted by the evidence that she heard from the two rival experts about the extent to which the evidence could be disentangled, the reasoning could be disentangled. And so we say that this is a particularly stark illustration of the principle from Perry, because although the Court of Appeal can either now read the judgments themselves or perhaps read the analysis which Mr. Lissack is going to produce of the reasoning, that's no substitute for the role of the judge, who was steeped not only in the written materials about the judgments themselves and the Venezuelan law evidence, but also in the historical context. In the context of the argument about whether or not the Venezuelan courts themselves were systemically corrupt and non-independent, there was a tremendous amount of reports, including by UN organisations, which set in context the decisions of the STJ which we were complaining about. The judge felt that that evidence didn't get as high as we needed it to go to establish that systemic lack of independence, but it was all part of the evidence in the trial, which the judge was entitled to take account of as part of the background for her analysis that there were rival factions, there were battle lines clearly drawn within Venezuela, and one couldn't disentangle the reasoning on which acts of the National Assembly were struck down by the STJ from the STJ's refusal to recognise the status of interim Guaidó as president. As she says, that they were only prepared to recognise him as a private citizen. And the reason for that is the same reason why they considered the National Assembly couldn't validly legislate, because it was in contempt. And so there isn't a severable strand of reasoning. It all comes from exactly the same place. And the constitutional crisis in which you're on one side or another. To which Mr. Lissack's only real answer is to say that what the Maduro Board relies upon as a legal error in respect of the starting point analysis infected Mrs. Justice Cockerell's view of the facts. And we say there's no basis for that criticism whatsoever. It's entirely commonplace for a first instance judge to go on to decide, although not strictly necessary to do so, that there are additional reasons why the argument doesn't work. It would be a completely unacceptable position if it could be said in the Court of Appeal on every occasion where that happens that the judge wasn't actually faithfully applying that approach, but in fact had allowed a legal error on the first part of the analysis to infect the second. And we say that the court needs to take at face value the approach that she says she took, which is entirely borne out by the care with which she set out the reasoning. She put it very clearly in terms of the different bases, 205 to 213, as to why she preferred the view that the reasoning couldn't properly be severed. And at 211, obviously, I emphasise that the passage there, the STJ sees Mr. Guaido's acts as invalid because it sees him not as interim president, but as a private citizen, and it sees him as a private citizen because it doesn't recognise the acts of the National Assembly, which he would say gave him that power. That sentence, we would suggest, encapsulates the whole issue. It's all part and parcel of the same analysis. And we don't need to go back to the passage of Professor Brewer-Caras's cross-examination at 77 and 78 of the transcript, which is at Supplemental 8, page 145. But if I could show you the position that was taken in writing, which is at Supplemental tab 15, page 416. 146.
That's the transcript.
Expert.
The joint statement.
Joint statement, beg your pardon. I had a wrong reference.
I think I'll look at that in the essential reading. Yes.
426. I beg your pardon. 426. Yes.
Sorry, on the we're looking in the essential reading bundle we got.
Since we were told this was essential reading, that's where I read it, I'm afraid.
So 426.
Which part of the document?
It's on.
There's an internal page.
Yeah, 13.
Thank you very much.
One sees there at the very bottom, row number 3, and it spans over the page. The topic is reasoning in the rulings about the recognition of Mr. Guaidó as interim president of Venezuela. The experts, in the second column, the experts differ in the existence of arguments and grounds of unconstitutionality that are independent from the status of Mr. Guaidó. And then one sees a high-level summary of the conclusions in Professor Brewer-Carriatis' report in the third column, where he opines that the recognition of the rulings that declare Mr. Guaidó's act to be illegal and null implies Mr. Juan Guaidó is not recognised as interim president of Venezuela. So it's all implicit and part and parcel. And then there's the views of Professor Arias in the right-hand column, where he expresses the contrary view that, in fact, you can sever the reasoning. And this court doesn't need to decide who was right about that. The point is that this was material that was before the judge. And in reaching her conclusions that you couldn't sever the reasoning, she was entitled to reach the view that she did after having heard from the experts and seen what they'd written and heard their evidence tested.
And the same point, with much the same paragraph references, seems to be made at item 1 on page 3.
My lord, yes, it's the same point. I mean, the experts were agreed, as you see from item 1, that all of the judgments assumed Mr. Guaidó was not president and Mr. Maduro was the president. That was common ground. And then item 3 is the extent to which there's some severable strand of reasoning. And Professor Brewer-Carrias thought it was all part and parcel. And Mr. Lissac says that this court doesn't need to really read the judgments because that you can look at his schedule and his analysis, and we don't accept that that's a proper approach at all, because the challenge for him, as I continue to emphasise, is that he's having to show that the judge's careful reading the judgments and the conclusions that she reached weren't open to her. And so she read the judgments, and you've seen the reference in her judgment to them being littered with reference to Mr. Maduro, to the lack of status of Mr. Guaidó being part of the warp and weft. These points are embedded in the judgments themselves, and we say it's not procedurally a permissible approach to invite the court to say, well, here's a table in which we've extracted some additional reasoning. It's not the actual underlying documents in the judgment which I'm seeking to have recognised, but nevertheless I want this court to overturn the judge based on that analysis. We say that it is clear from the care with which she set out these reasons that these are decisions which were open to her, including points of detail that Mr. Lissac doesn't touch upon, like the fact that if this was to be a quashing of a presidential act, it would have needed to progress in an entirely different chamber of the STJ than the constitutional chamber. There is a political administrative chamber as a judicial review of administrative act chamber, and had the STJ been regarding him as president, it would have needed to proceed in that chamber. And the next topic on this was just whether it's rendered moot, but I don't think I'm going to get there within the next minute.
Sorry, the point you've just made, is it reflected in those paragraphs of the judgment? Is it the different chamber? Oh, yes, it is. I can see.
Yes, yes.
Thank you.
Yes, all right, well, if that's a convenient moment, we will adjourn now.
Yes, ma'am.
The point about whether it's rendered moot, you mean Mr. Lissac's
Mr. Lissac's
now primary way of putting it?
Yes, exactly. The post-trial point, yes. I'll probably be 5 minutes on that first.
Yes, all right, well, looks if we're in good shape to conclude this appeal tomorrow.
Yes.
Very good, 10:30 tomorrow.